The supermarket price wars are back, with one major retailer shaking things up with a big announcement this morning.
Yeah, Coles is slashing prices on some of its most popular items, with more than 300 products marked down. And even better news, the reduced prices will now be frozen until July.
Hello, I'm Paul Barry. Welcome to Media Watch. And that was Seven's Sunrise last Wednesday, trumpeting a big announcement that a major supermarket was putting a range of items on sale. Hot news! It was on Sunrise, which was delighted to have the scoop.
Coles has given Sunrise special access. Here's reporter Tamraba.
And with that special access, Sunrise produced one of the most extraordinary puff pieces we have ever seen.
The cost of 376 items not only dropped, but locked in that price for at least 12 weeks.
That tagline, courtesy of a Coles press release at 6 o'clock that morning. And along for the Sunrise spruik was the company's Chief Operations Officer, Matt Swindells.
That's beef, that's breakfast, that's big brands, and that's bigger packs.
Swindells was the only person Sunrise interviewed. And he wasn't just on the shop floor, he was in the kitchen too, boosting Coles' home brands.
So this is a bolognese sauce that your kids will love, but it's got all the vegetables already blended in it, hidden away.
On and on and on it went, as Sunrise went the full Monty.
Diced beef is being reduced by 15%, now just $11. Making a casserole will now set you back $5 less, with all the essential ingredients now dropped and locked.
Dropped and locked again. Yes, it was blue ribbon PR, with any attempt at journalism out the window.
Spaghetti for under $3, shepherd's pie for under $5, and curried beef casserole for under $6.
We've long warned about the dangers of advertorials eroding the credibility of news and current affairs. But what's shocking about Sunrise's 4-minute Coles spruik, yes, 4 minutes, is that it wasn't actually sponsored content. Coles says it didn't pay a penny, nor was it part of any advertising deal with Seven. Instead, the supermarket pitched the story and Sunrise snapped it up. And what's all this free publicity worth to Coles? Media analyst Steve Allen says editorial is valued at around 3 times advertising costs. Telling Media Watch,
our airtime valuation for this Sunrise segment is $82,500.
That is 20 grand a minute. And rather than just repeat Coles' claim about its commitment to family budgets, why did Seven not check competitors? Or point out that regular surveys by choice find rival supermarket Aldi offers much better value for money? Or mention that Coles' first half profit jumped 17% to $643 million. As soaring grocery prices helped it beat analysts' forecasts. Sunrise failed to do any of those things. And while other media also went to town on the Coles announcement, none was as lavish as Sunrise. On 9 News, they at least included competitors like Woolworths and Aldi. So, what does the country's top-rating breakfast show have to say? Seven told us the Coles announcement was a major news story, adding,
if Media Watch seriously has an issue with reporting on one of Australia's biggest supermarkets dropping prices in a cost of living crisis, God help us all.
Sure, cost of living is a critical issue, but 4 minutes on the Coles catalogue? That's not journalism, it's straight out PR. And with such lazy media at its beck and call, it makes you wonder why Coles bothers to advertise at all. But now, to privacy and the media. And here is a question. If the media in Australia invade your privacy, what can you do about it? Answer, beyond a complaint to the Press Council or ACMA, not much, unless what they're saying is untrue, in which case you might be able to sue for defamation. So, the media can happily carry out celebrity hits like this. Publishing a photo of Laura Bingle, naked in the shower, as Women's Day did in 2010, which we have further blurred. Outing Hollywood star Rebel Wilson as gay, as the Sydney Morning Herald did last year. And snapping Kate Ritchie outside a Sydney drug and alcohol clinic, revealing she's been in rehab, as the Daily Mail did in 2022. Or indeed hounding a Sydney limo driver for days after he was identified as the city's COVID patient zero.
The driver said his reputation is ruined and his life destroyed, and he's sorry. The couple say they have fully recovered physically, but restoring the damage may take much longer.
With intrusions like those increasingly common, it's no wonder that many people want action. And now the government is promising to take some. Last month, a major review of the Privacy Act recommended substantially strengthening the law, and the media reacted with alarm.
Media rivals unite against chilling federal privacy law proposals.
Media companies slam proposed reforms to Australian privacy laws.
Media companies warn changes to privacy laws would have a chilling effect on press freedom.
And the Australian's media writer took to Sky News to warn.
This could open up a giant can of worms and be very problematic for the media industry because it could suppress stories that people don't want written about them.
Tonight we're going to see what it might mean for the media if the changes go ahead, and ask if stories like those on Lara Bingle, Rebel Wilson, Kate Ritchie and the limo driver would be publishable in future. We're going to focus on one key change urged by privacy advocates, which would allow people to use the courts to stop stories being published or to sue for damages when they are. Media organisations in Australia's Right to Know coalition, which includes the ABC, told the Privacy Review that this will have
a detrimental impact on freedom of expression and freedom of the media, and will undermine news reporting.
And if you look at what's happened in the UK, you can see why they might be concerned. Because the UK courts have allowed Russian oligarchs and other mega-rich to spend millions on defamation and privacy actions that muzzle the media and prevent exposure. In January 2022, campaigning Conservative MP David Davis told the House of Commons,
"These people use our justice system to threaten, intimidate and put the fear of God into British journalists, citizens, officials and media organisations. What results is injustice, intimidation, suppression of free speech, crushing of a free press, bullying and bankruptcy."
And he went on to brand it
lawfare.
Mostly this lawfare relies on defamation laws, but the UK's privacy laws are proving increasingly popular because they don't require plaintiffs to prove that what's being said about them is untrue. And rightly or wrongly, this has limited what the media can report. In 2018, for example, singer Cliff Richard won a case against the BBC after it broadcast live pictures of police raiding his home during an investigation into an alleged historical sex offence against a 16-year-old boy. Richard, who was cleared by police and never charged, sued for invasion of privacy and was awarded substantial damages. And in 2022, a US executive in a big multinational company won a landmark case against Bloomberg, which had reported that the man was being investigated by police for corruption. Bloomberg's story was true, yet it still lost the privacy case. And as a result, it's now almost impossible for the UK media to name suspects in police investigations, even though this can prompt new witnesses to come forward. And way back in 2004, in the case that began it all, model Naomi Campbell successfully sued the Daily Mirror for publishing photos of her emerging from a Narcotics Anonymous meeting in London. The Mirror claimed the photos were evidence she had lied to the public in swearing she had never used drugs. Surely a reason to allow the story. But not according to the courts, which ruled that in attending the meeting, Campbell had a reasonable expectation of privacy. So, does Australia's Privacy Act review propose a similar right to sue? Answer, yes, adopting a recommendation from the Australian Law Reform Commission in cases of
intrusion upon the plaintiff's seclusion or private affairs, including by unlawful surveillance, or misuse or disclosure of private information about the plaintiff, whether true or not.
Any invasion of privacy would need to be serious, to be actionable, and the victim would have to show the invasion was reckless and intentional. Plaintiffs would also have to prove that the public interest in protecting their privacy outweighed the public interest in the media's freedom of expression. So, are those protections enough to reassure the media? No, they are not. Justin Quill, who's fought many a defamation action for News Corp, told Media Watch,
"A tort of privacy might make celebrities and billionaires sitting on their yachts more comfortable, but at what cost to investigative journalism, free speech and the public's right to know? It will likely make dodgy businessmen and women and politicians feel safer as well."
But Dr. Michael Douglas from the University of WA Law School is adamant that such fears are exaggerated, telling us,
"The media's recent coverage of itself with respect to this reform is predictably hysterical. The introduction of a statutory tort for serious invasions of privacy is long overdue. Experts have been calling for it for years. Media voices are worried about it because it means some will be held accountable for dodginess they might currently get away with."
And Professor Barbara McDonald, who ran a 2014 inquiry into breaches of privacy and is one of the people driving the changes, agreed, arguing there would be
an inbuilt upfront protection of freedom of speech and the freedom of the media to investigate and report on matters of public interest.
And she adds that where someone is seeking an injunction to stop publication, it's proposed that
A court must have particular regard to freedom of expression and any other matters of public interest.
So, what might it all mean for readers and viewers? We asked our three experts which of the celebrity stories we saw at the start could be hit with a privacy action. Lara Bingle's shower pics? Answer, yes. Rebel Wilson's relationship? Yes, again. Kay Rich's rehab? Yes, again. And the COVID limo driver too could seek damages from the media. All would have a chance of success. Fair enough, some would say. Others that celebrities deserve it. But what about this famous front page from 2018?
Bundle of choice!
Deputy PM expecting a baby with former staffer.
Barnaby Joyce might not succeed, the experts reckon, because he is a public figure and a politician with no reasonable expectation of privacy. But his now wife might have had a claim, so that too may have been off limits. And who knows what the courts would decide on stories like these. Tim Paine's sexting scandal, which cost him his job as Australian cricket captain. The ISIS brides and their kids, snapped by a news crew, having a meal at McDonald's. And any of a number of toilet dramas, like this one, involving high-paid footy stars. And that's not all. We asked Professor McDonald if other sorts of stories could be caught. She said,
Yes, close-up photos of grieving family members for a start. The pictures and footage of a drunk woman who is picked up by police to be taken home, as I saw recently. These are ordinary people who are just as entitled to privacy as any celebrity.
That would have the capacity to affect multiple stories, like the media's Melbourne Cup coverage, for example, where colour features like this are a Daily Mail and TV staple. Giving those people the chance to sue, and the same to random people in footy crowds, would be a massive headache for the media. And Justin Quill says the idea is nuts. It could also tie up the media in the courts forever. The Right to Know Coalition, meanwhile, argues that the media face enough restrictions on reporting already, including on
matters involving children, family law matters, adoptions, coronial inquiries, sexual offences, domestic violence, jurors, communication with prisoners and other detained persons, and security matters including national security.
The media also has to contend with surveillance and listening devices legislation, non-publication and suppression orders, and common law actions for
trespass, nuisance, breach of confidence, defamation law, malicious falsehood and contempt.
All in all, it is quite a list. And in a country where the court's strict interpretation of defamation law is already a nightmare for the press, do we really want to give judges more power to rule out what we can read? Short answer, in my opinion, surely not. But now, to a Press Council slapdown for Melbourne's Herald Sun, which you may recall ran several hit pieces on Premier Dan Andrews ahead of last November's state election. Like this exclusive about a 10-year-old accident between a cyclist and a car driven by Andrews' wife. Or the amazing steps that took down a premier. A nod to conspiracy stories about Andrews' back injury, which saw him off work for 15 weeks. So, were those the ones in the Press Council's sights? No, it was this story, 8 days out from polling day.
Daniel Andrews' Chief of Staff met with election fixer.
Which featured on page 1 of the paper, plus another 2 pages inside.
Premier access for Vote Fixer.
Revealed. Andrews' Chief of Staff met with man caught boasting about rorting Victorian election.
That man was the so-called election whisperer Glenn Drury, who in a leaked video boasted he could game the system and manipulate the makeup of the state's upper house. For the average reader, the subtext was clear. The Premier's office was up to no good and was out to fiddle with the election outcome. And that's exactly what the Press Council found.
By making repeated and prominent references to the election fixer, the article unfairly implied that Daniel Andrews' office was involved in election fixing in the context of the then upcoming election.
That, it said, was a breach of Principle 3, which requires publishers to
ensure that factual material is presented with reasonable fairness and balance.
But that's not all. The Press Council also said the story breached Principle 1 because the Herald Sun
failed to take steps to ensure factual material is not misleading.
Of course, the Herald Sun rejects those charges, arguing that its story was fair. And in its defence, it pointed to paragraph 6 of the report, which quoted a spokesperson for Daniel Andrews saying,
Mr Drury had one meeting with the Premier's office in 2019 when he was a staffer for the Derrinhinch Justice Party.
Yes, one meeting in 2019. So all those screaming headlines, including
Premier access for Vote Fixer,
relied on one meeting more than 3 years earlier. And was that meeting about anything nefarious? Not according to Daniel Andrews, who told journalists on the election trail.
I think the subject was about resources and how many staff the Hinch Party would get.
Hardly cooking the books. So, just another Herald Sun beat-up days ahead of an election which Dan Andrews won in a landslide. And a story the Press Council was right to slap down as misleading and unfair, making it the 6th adjudication to go against a News Corp masthead in the last 6 months. That's all from us for tonight. There's more on our website, including statements from Seven, and from Michael Douglas, Barbara McDonald and Justin Quill. And don't forget Media Bites on Facebook, Instagram and YouTube. Until next week, goodbye.